Hello, and thank you for joining our third annual Day with DISA. Before the session gets started, let's go over a few things. A copy of the presentation will be available to download once the session has ended under the Materials section. If you have questions about the information in this session, enter them in the Q&A section below, and the speaker will answer them once the session has ended. If we don't get to your question, we'll reach out to you at the end of the conference. If you have questions about the topics or trends that are mentioned throughout Day with DISA and how they pertain to your company, and you'd like to reach out to one of our team members directly, hit the chat icon at the bottom of daywithdisa.com and you'll be connected directly with one of our team members. Thank you for attending live. Each of our live attendees is eligible for our prize drawing at the end of the conference. And each session that you attend live increases your chances of winning either a Nintendo bundle or a brand new iPhone 12. Finally, I'd like to take this time to thank all of our sponsors for their participation in Day with DISA. Specifically, I'd like to call out CRL, our title sponsor for 3 years running. We'd like to thank our platinum sponsors, OraSure, Quest Diagnostics, Samba Safety, and Psychomedics. All of our sponsors' support is greatly appreciated. With that, let's get started. Enjoy your session.
Hi, and thank you so much for joining us for this session of Day with DISA. Today, we're going to be talking about background screening hot topics. Today, we're joined by an industry-leading presenter that you might be familiar with from giving the keynote or other presentations at conferences like the Professional Background Screening Association. Today, we have Pam Devata, a partner at Seyfarth Shaw, and she's focused on everything relating to background screening there. Pam, thank you so much for joining us today.
Thanks so much for having me.
Well, Pam, we are ready to get started if you are, so go ahead and take it away.
Great. Hi, everyone. This is Pam Devata at Seyfarth Shaw, and I'm thrilled to be here today to talk with you and the folks at DISA about hot topics in background screening. We've got a big agenda today, so we're going to go ahead and dive in and get started. We're going to focus a little bit on the increase of Fair Credit Reporting Act disclosure litigation. We're going to talk about adverse action and some of the hot topics regarding that. A little bit more about ban the box rules in 2020, some of the new litigation and legislation that's come down. We're going to focus for a few seconds on the FDIC Section 19 rule for financial industries. And then finally, we're going to go to best practices to stay compliant. All right, so let's go ahead and dive right in. We're going to go ahead and start talking about our first topic here, which is disclosure and authorizations. Under the Fair Credit Reporting Act, an employer has 4 main responsibilities. One of the main responsibilities that they have is that they must provide a standalone disclosure consisting solely of the disclosure if they are going to get a background report for employment purposes. This has been the subject of more litigation in the past 5 years than, frankly, any other types of claims under the Fair Credit Reporting Act. That's really why we're spending so much time here. So what does the statute say? Well, number one, the statute says you must provide to a candidate or an applicant or a employee, if you're doing this post-employment, disclosure for the fact that you're going to be running a background check. The key is that this disclosure must be in a standalone document consisting solely of the disclosure. The problem is that the Fair Credit Reporting Act is sometimes very confusing in the way that it's written. Because in one section of the statute, it says that the document must be a standalone disclosure. And in the very next sentence, it says that the written authorization that you get from the consumer can also be part of that same disclosure. So it's tremendously confusing. And this has really been the subject of a ton of litigation here. So let's dive a little bit deeper into that. What does that really mean? Well, we learned a little bit last year in 2019, and then again earlier in this year, March of 2020, with 2 cases from the Ninth Circuit Court of Appeals that really put a fine point on it. And this litigation really started back in 2015 with a case called Singleton versus Domino's Pizza. And since 2015, for the past 5 years, we've seen different iterations of these types of claims. No court of appeals, however, has actually opined on this issue until last year. So the two cases where we really got clarity on the issue of disclosure and authorization forms were two cases that are referenced on the slide here: Gilbert versus California check cashing stores, and then Walker versus Fred Meyer. Well, what did those two cases say? Specifically, they talked about the fact that if your disclosure has any extraneous information, potentially it's likely going to be unlawful. We've seen claims all over the country asserting things from a semicolon being extraneous language to a signature on that document being extraneous language. But the Ninth Circuit was very specific, and they said that references to things like inspections of files, or perhaps the notice and scope of investigative consumer reports, are going to be potentially extraneous. When this litigation started back in 2015, what we really saw was if you have a reference to a release of liability or a waiver of liability, that would be extraneous information that could be confusing to an applicant. Now we're seeing anything that you could throw the kitchen sink at, frankly, that's not just the pure disclosure and or the pure one-line authorization that's going to be challenged. So information that's in your disclosure form, references to things like throughout the person's employment, for example, could be deemed to be extraneous. Having references to any state laws. So remember, you've got the Federal Fair Credit Reporting Act that governs the use of consumer reports. In addition to that, though, you've got a myriad of different state and local laws that have their own regulations and statutes that you may need to comply with. In addition to those, you've got things like you might have an additional notice that's required in California, for example, or you might have something that's required like a checkbox in California, Minnesota, and Oklahoma. So references to those state laws on that master disclosure form, at least according to the Ninth Circuit Court of Appeals, are potentially going to be extraneous and are ripe for litigation. References to a permissible purpose, such as an employment purpose, for example, is okay, however. And you can and are allowed to provide those documents as part of your hiring process or your application process. But please understand, you cannot provide that information in the application. You need to have it be a separate standalone document. The authorization doesn't need to be separate, but the disclosure does. You can see that this is really clear as mud, and there's been a ton of litigation about this. And talk a little bit about why it actually matters. The issue here is, under the Federal Fair Credit Reporting Act, there's multiple different types of claims, really two major types of claims: negligent noncompliance and willful noncompliance. For someone to sue you under the Fair Credit Reporting Act, they could allege that you were negligent in your noncompliance of the law. And what they would be able to get is actual damages. Usually it's back pay. Sometimes it might be emotional distress or other compensatory damages and attorney fees. These are very, very rare as it relates to disclosure forms cases. What we normally see is an allegation that you were willful in your noncompliance. Willful generally means a reckless disregard for the law. And why is that important? It's important because instead of getting actual damages, there's what's called statutory damages under the statute. And you can get statutory damages of between $100 and $1,000 per violation. So taking that back, the reason why that's important is you can have one person who has one potentially violative form, and a class action can be lodged against you as an employer. So what we generally see is claims that allege anyone on whom you have run a background check in either the last 2 years or the last 5 years. The reason by that is because the statute of limitations is the earlier from 2 years from the date the person knew or should have known, or 5 years from the date of the consumer report. So think about it. This has nothing to do with whether you've hired the person whatsoever, but anyone on whom you have run a background report in the last 2 years, any one person could file a lawsuit and claim that the information that you gave them was in violation of the Fair Credit Reporting Act, and it allegedly, quote unquote, harmed them because they weren't given the information that they were supposed to be given, or they were confused because it wasn't clear and conspicuous in a standalone document. That's why it's so critically important that you understand what your forms say and that you make sure that you have your document legally reviewed on a regular basis. We generally recommend that you do it on at least an annual basis or every 6 months, because the law really is changing quite rapidly. So if we move on to our next topic here, another issue is what's called investigative consumer reports. And when we talk about a consumer report, basically under the law, what that means is anything that a third-party background screening company or a third-party consumer reporting agency assembles and evaluates for you as an employer for an employment purpose. And those garden variety consumer reports generally are things like a criminal history or a driving record or credit report, for example. So anything that bears on a person's character, general reputation, personal characteristics, mode of living, or credit. Unlike a garden variety consumer report that we just talked about, which again would be a consumer report that deals with criminal history or credit history or a driving record, an investigative consumer report is a very special type of consumer report. It's also one by a consumer reporting agency, and it's also one that bears on someone's character, general reputation, personal characteristics, or mode of living, but it is one where that information is obtained by personal interviews. So the two special things about investigative consumer reports are it's not credit, number one, and number two, it's obtained by personal interviews by your third-party consumer reporting agency. Why does this matter? Because both the Federal Fair Credit Reporting Act and many of the state laws that we're talking about and that have implications here require additional disclosure information. And although no court has held it yet, there has been arguments by the plaintiff's counsel and the plaintiff's bar that having information as it relates to investigative consumer reports in your federal disclosure for background checks potentially could be in violation. So you want to make sure you know the difference and understand that. Now, please note this does not pertain to when you yourselves are going to be getting reference checks not by a third party. So if you're an employer and you're picking up the phone and getting reference checks, for example, the Federal Fair Credit Reporting Act does not apply. But if you're using your third party to go and get reference check information, personal or professional references, and sometimes employment verifications when they're asking more than just the job, that title, the specific dates of employment, for example, that might lead to the definition of an investigative consumer report. And there are additional disclosures required with that. Moving on, we're going to now focus on the issue of some other requirements in terms of the Federal Fair Credit Reporting Act and talk a little bit about what can be extraneous and what is not extraneous. So let's take a quick pop quiz here. Can I include a release of claims or a liability waiver in my disclosure and authorization? And the answer is absolutely not. This is what we call the low-hanging fruit, right? This is where we have the most developed case law, and you want to be really, really careful about making sure that if you have any release of liability in your disclosure, that you take that out. Now, what about your authorization? Well, remember, your authorization does not have to be a standalone document. But what we generally recommend, and again, we're not giving any legal advice or counsel today, but what we generally recommend here is that you separate the disclosure and the authorization forms from one another. And a best practice really is not to have any release of liability in either one of those documents if you want to be, just in case, for example, the disclosure was held not to be separate and apart from the authorization. The second pop quiz, can I include my disclosure and authorization in my employment application? The answer is you can include it as part of your hiring materials, and it can be a part of your authorization process. But you want to be really careful about having it be part and parcel of your application, because then it may not be a standalone disclosure under the law. The other thing is certain jurisdictions, like New York City, for example, it's going to be a per se violation of the law for you even to mention the fact that you're running a background check prior to conditional offer of employment. And so certainly in those jurisdictions, you want to be really careful about making sure that you are not providing your disclosure and authorization forms prior to a conditional offer of employment, because that could be deemed to be a violation of the law. What if you want to share a report with a third party? If you're a staffing company, for example, there are lots of different laws and regulations relating to this, because certainly as an employer, you don't want to be a consumer reporting agency. So under the Federal Fair Credit Reporting Act, employers have their own set of obligations, but CRAs have additional sets of responsibilities, and they're very different. And so if you share that as an employer, you could potentially be deemed to be a consumer reporting agency, which you really don't want to do unless that is your business of being a consumer reporting agency. My forms refer to credit checks, but we don't order credit checks. Is that an issue? And so you got to be really careful with credit. So a couple things to know. Obviously, we're talking about hot topics and background screening, but we do other presentations where we talk a little bit about the use and restrictions of credit checks. There are 10 different states and jurisdictions right now that prohibit or restrict an employer's use of credit checks. However, what you really need to understand is that in certain jurisdictions, you have to make sure that you get an additional disclosure form or mention the fact that you're going to be running credit. However, in other jurisdictions, again, New York City is often one of the most challenging jurisdictions. If you mention credit in your disclosure form and you are not going to be running credit reports, that's a per se violation of the Stop Credit Discrimination in Employment Act under New York City law. So you want to be really careful about that. So the general threshold rule is if you're running credit, you need to mention it. If you're not running credit, you can't and should not mention it at all. What about putting the authorization on the same page or screen as the disclosure? Well, the question really is going to be, how sure are you that it is a standalone disclosure consisting solely of the disclosure and then, for example, a one-line authorization? Anything else is going to be ripe and low-hanging fruit, unfortunately, for potential litigation. So be cautious about that. We're not saying it can't be done, and indeed the statute says it can, but you really do want to be cautious and make sure that you have your forms reviewed by counsel who, either internal counsel or external counsel, who's really knowledgeable about this ever-changing area of the law. How about putting your vendor's name and contact information on the disclosure and authorization? Well, you should know that that's actually required on the standalone California form. That's a separate disclosure or notice that is required under California law. California has actually two iterations of the Fair Credit Reporting Act, one called the Investigative Consumer Reporting Agencies Act and one called the Consumer Credit Reporting Agencies Act. And it's required under both of those, but it is not required under the federal law. Not that you cannot have it, but be careful because it's not required under the law. How about states with unique requirements? There's a myriad of them. Many states have additional requirements that you need to either provide an additional notice or you have to provide additional information. What many companies do is they have a other state law notices form, for example, that lays out those additional state law requirements that are not within that disclosure. And can you include those state disclosures on the disclosure and authorization? Again, what we learned from the Ninth Circuit Court of Appeals is if you have them on the disclosure, it's likely going to be potentially in violation. However, if you have them on the authorization, it's probably going to be okay. So make sure you understand and know that as well. All right, so now we're going to move on to the second topic, which is adverse action. And remember, I said that there were 4 responsibilities under the Fair Credit Reporting Act. The 2 biggest ones that an employer gets sued for is the disclosure and authorization forms, and specifically that standalone disclosure argument, and then adverse action. And so adverse action under the FCRA is very broadly construed. It can be anything that is adverse to the interest of the consumer. What does that mean? It means if you don't hire the person. It means if you don't promote the person. It means if, for example, you do hire the person, however, you require something extra, like additional checks, background checks, for example, or other information, for example. So you want to make sure that you understand that it's a very broadly construed. Would even be, for example, if you're a staffing company and you don't place someone in a certain position, yet you place them in a different position. So what does the law require? Well, it requires sort of a 3-step adverse action process. So the first is think of it like due process. It's a pre-adverse action notice. You basically give the opportunity for the person to view the report. So you give them a copy of their background report, you give them a copy of their summary of rights under the law, and you give them any state or local notices. And there's a variety of different things that are required depending on the local jurisdiction. And we talk about ban the box laws a lot. We're going to get into that in a few minutes. And a requirement of what you have to put on your pre-adverse action notices. But it basically gives the person the opportunity to dispute anything that's incorrect or inaccurate in the report prior to you taking adverse action. Then the next step that we're going to go to is sort of that secondary step, which is the waiting period before you get to adverse action. The waiting period under the FCRA is undefined. So the Federal Trade Commission has basically said that a reasonable period of time, and that's really what the statute says, is that you must wait a reasonable period of time. The FTC has opined that that is 5 days. And so you're going to need to consider whether you're mailing this letter, whether you're emailing this letter, do you have a way to track whether the person has opened it? And there are many, many different jurisdictions that have very specific requirements. So for example, New York City requires that you must wait at least 3 days, business days, from the date of the receipt of the report. And in San Francisco, you must at least wait 7 days. Now, those are calendar days. So there's a question between calendar and business days. But as a general rule of thumb, if you wait 5 business days, you're pretty good in almost all jurisdictions, with the slight issue of potentially Philadelphia that requires 10 days. Once you wait, then what can you do? We'll talk about adverse action, right? So now we have the final decision. And now this is a written correspondence where you're now telling the person, I regret to inform you, we are withdrawing your job offer. Now, at this point, remember, they've already seen the report. They've already gotten a summary of their rights. They've had the opportunity to dispute the information. And then and only then, when you, at that point, can you then have the final adverse action decision. And you'll notice on their slide, there's very, very specific things that you must say to the individual. You have to give them the Consumer Reporting Agency's contact information. Again, you have to tell them that they have the right to get a copy of the report, again, even though they've already gotten it. There's additional state and local law notices, for example. And again, it's really important that you do this in writing. Otherwise, you're just not going to be able to meet all of the different compliance obligations under the law. So let's do a quick pop quiz on adverse action. Do the notice requirements under pre-adverse and adverse action apply to current employees? And the answer is absolutely. It's not just applicants. Anytime you take adverse action in whole or in part based on a consumer report, and again, listen to that, in whole or in part based on a consumer report, you want to really make sure that you're following the adverse action requirements. That goes to the second question. If it's only part of the reason, yes, you still need to comply with the pre-adverse waiting period and then adverse action requirement. What happens if that person submits a dispute to your background screening company in between? So let's say DISA has run a report, for example, and in the meantime, there's been a dispute. Well, a CRA has 30 days to reinvestigate that information. They usually do it a lot faster than that, frankly, within just a few days. But you don't have to keep the job open, but I'm going to tell you the best practice is that it generally is recommended that you do keep the job open. The reason why is because otherwise, right, let's say that the information is actually wrong. So now you've made a decision potentially on the fact that this individual is not going to be hired with incorrect information. And certainly you don't want to do that after you've gone through all of the time to find your correct candidate. Can a background check company send the notices for you? The answer is absolutely, but remember, it's still your obligation under the law as an employer, as an end user, under the Federal Fair Credit Reporting Act, to make sure those notices are being sent, to make sure they're compliant under the law, and that they have the accurate and correct language that you want to have, because at the end of the day, you're going to be the one that potentially gets sued. So make sure that you understand that. And then last but not least, can you call the applicant in advance and give them a heads up? And the answer is, you got to be really careful about that. And the reason being is because if you call the person and say, hey, listen, Callie, there's a problem with your background report, that could be construed as adverse action. So as a best practice, what we generally recommend is that you provide the pre-adverse action letter, then you call and talk to the person when they have the report in front of them. And then you say, we're not taking any decisions, we're taking this under advisement. All right, we're going to move to some best practices here. So as it relates to the disclosure and the authorization forms, absolutely make sure you follow the specific adverse action requirements under the Fair Credit Reporting Act and local and state jurisdictions. Make sure that you use language such as, for example, review, and that you don't make any bright line decisions. If you're going to have one of your background screening companies do a preliminary grade for you, for example, or in the pre-adverse action letter, say that you're making a preliminary decision or you haven't made a decision yet. Make sure you wait at least 5 business days between the pre-adverse and the adverse letter. Obviously, if there's a dispute that's filed by a consumer, you want to make sure you understand the outcome of that, because you want to make sure you get the most accurate information when you're making your employment decision, and make sure that you understand what they've said in that dispute, or if they provide you any information. In terms of be careful. Don't use conclusory language like ineligible for hire, for example, in your pre-adverse action letter. So now we're going to go to a little bit of a similar topic, which is ban the box. What ban the box means is it's basically a fancy way of saying when an employer asks about whether or not someone has been convicted of a crime. And it's called ban the box because it's banning, for example, the question of, with the box, check yes or no, have you been convicted? And so this is going to apply across the board, regardless of whether or not you are getting this information from a consumer reporting agency or whether you're going to get this information yourself. But the question is going to be, there's lots of different jurisdictions and lots of local and state jurisdictions that really prohibit when you can ask about criminal history and what you can ask about criminal history. The other thing that's changed with these ban the box laws, and this started back in 2012 with the EEOC criminal history guidance that we're going to talk about briefly, is the issue of there's now additional requirements in those pre and post adverse action letters. So for example, in the pre-adverse action letter in certain jurisdictions like Portland, Oregon, and some counties in Maryland and San Francisco, you now have to actually provide the specific reason for the reason that you're potentially taking action. So for example, instead of saying something like, we're thinking about taking action in whole or in part based on the report, you would need to say, we're thinking about taking action specifically because of that felony burglary conviction that you had 5 years ago. And those are some of the jurisdictions, but there's many more, Austin, Texas, and many others, for example, that you need to comply with. And then finally, there are certain jurisdictions, I call them the most challenging jurisdictions, New York City and Los Angeles, that have fair chance acts that require you to do an individualized assessment in writing to the individual and then provide them a copy of that Fair Chance Act form with your specific analysis of why that criminal history is job related and goes through the individualized assessment factors required under those Fair Chance Act laws. New in 2020, ban the box has been around for many years, but new in 2020, we've got a number of different state and local updates. You'll see that just this year, you've got Waterloo, Iowa, Suffolk County, New York, Maryland as a state, St. Louis, Missouri, and Grand Rapids, Michigan have all added additional requirements in addition to the myriad of other state and local requirements that have already been in existence. And then on the federal level, if you are a defense contractor, there's now ban the box requirements for that too. So understand it's not just if you're a private employer. All right, so we're going to talk a little bit now very briefly about financial services employers. And if you are a financial services company, you're very familiar, I'm sure, with the FDIC and Section 19. So understand that Section 19 of the FDIA specifically requires that you, as a financial services company, can't hire people that have very specific criminal convictions. What happened was there's a brand new rule now, and in July it was codified as a statement of policy. It now excludes all expunged and sealed records, which is a change. So if there's an expunged or sealed record, you don't have to take action on that. And it also modifies the rule about what's called a de minimis offense. So for example, it used to be for the fact of these convictions that if it was a de minimis offense, you could only have one de minimis offense to potentially qualify for a waiver or an exception. Now you can have two de minimis offenses. So it broadens it and it opens it. What they really found was that people that were applying for this exception were always passing through. So they've changed that a little bit to make it a little bit easier for these very, very minor offenses. It shortens the waiting period between those offenses, and it increases the simple threat threshold, for example, to $1,000, which was an increase of what it used to be. It also adds a list of offenses in terms of, for de minimis offenses, of those involving use of fake ID to purchase alcohol. That is now a potential de minimis offense. So what this really means is, for financial employers, is just make sure you understand the rules, because they've changed a little bit this year. So let's talk a little bit about the key takeaways as we wrap up for best practices under the hot topics of background screening. So number one, make sure you review your forms. Review your disclosure forms, review your authorization forms, review any other state and local law notices. So including your, for example, your adverse action letters, what they have in terms of insets, what they have in terms of language in them. Make sure you understand what your employment application says in terms of ban the box or not, and make sure that, that you are compliant then with the law. Number two, make sure that you consider removing your disclosure as part of the application. It used to be that there was that big paragraph at the end of every employment application that allowed for checking of a background check. That's not going to do it anymore. It needs to be a standalone disclosure consisting solely of the disclosure. Number three, even if you have a standalone disclosure, ensure that you don't have a waiver or release of liability in that disclosure form. That's going to be the easiest litigation and low-hanging fruit on that. And then number four, make sure that you watch for this extraneous information. You got to watch for things like extraneous information on your report. You absolutely are allowed to certify that the person has provided you correct information, but don't do it on the disclosure. Make sure that that is separate and apart and on the application form as well. Make sure that you get other authorizations and other of those certifications not on the disclosure form. You can do it as part of the application, but not as part of the disclosure as well. The other thing to do is make sure that you are training your managers and recruiters. If you've got an applicant tracking system, make sure you turn off those auto rejection letters. Nobody likes to be told multiple times that they are being rejected. So make sure, if it's based in whole or in part on a background check, that you have a separate and distinct process, which is that pre-adverse and adverse process. Make sure that your state and local notices should be based on where the person lives or works, and not anything else, right? So it doesn't matter where the record is, but it matters where the person can sue you. So make sure you're providing correct state and local notices where the person lives and or where the person works. Make sure you keep up with the myriad of different ban the box state and local laws that are changing all the time. As you saw, we had like 7 different new ones just this year. And my favorite is, don't allow people to start before a background check is done. It is very, very hard to do, but it's Murphy's Law, that as soon as you start somebody based on the fact that the background check is going to be clear, that's when something comes up. And now if you think about it, you can't just terminate the person, right? Because you need to give them the pre-adverse, you have to wait a certain period of time, and then you have to give the adverse action. And if it's a serious violent offense, you want to get them out of the workforce, but potentially you're going to need to pay them for that time. And otherwise, not doing so is going to be adverse action. So be really careful about that as well. The other thing is, make sure that you inquire only about criminal history after conditional offer of employment is extended. What I mean by that is, make sure that you understand that there's ban the box laws that prohibit you from asking earlier than that. That is sort of the one size fits all rule. It's the most conservative rule. Only ask about convictions and not about arrest records. There's a whole myriad of laws that really specifically restrict your ability to ask about non-conviction information. Similarly, you can't ask about sealed, expunged, restricted, juvenile, parted, impounded records in a majority of states. So you really want to make sure you have your criminal history question reviewed. We get a lot of questions where people ask, well, should I even ask about criminal history? And I have to tell you, it's our strong my certainly personal strong recommendation that if you are going to ask about criminal history and you have a perfectly appropriate question that's been legally vetted, it's a great opportunity because it allows the person to have good judgment and either reveal the conviction and give you explanation about why, for example, it's still job related and consistent with business necessity. But it also allows people to falsify, right? And that's certainly judgment. And so you want to see that good judgment when you're asking, again, post-conditional offer of information. Review your policies, review your applications and procedures to make sure that you're not running afoul of any laws, and then absolutely monitor legal developments because there's lots of different guidance, different interpretations like we heard from the Ninth Circuit Court of Appeals even just this year. And with that, I'm going to turn it over and we're going to open up for questions. Thanks so much for joining us for Hot Topics in Background Checks.
Pam, that was great. Thank you so much.
You're welcome.
Before we get into questions, just a little bit of housekeeping. If anyone there has a question, please submit it at the bottom right in the Q&A section. If we're unable to get to it right now, we just run out of time, we'll reach out to you after the conference and try and address your question. If you have an interest in downloading a copy of the presentation, there's the materials section at the bottom right. Just go ahead and click on that link and there should be a copy of the PDF there to download. Pam, as we dive into questions, first question is, what about pending cases? Do I need to send adverse action for those?
Yeah, that's a great question. And the answer is, whether or not you can even take action on pending cases, right? Because there's a lot of different states and local jurisdictions that have restrictions on when you're allowed to actually use arrest records in making an employment decision. And so on the one hand, you've got the situation where a pending record is like an arrest, but it's not a conviction at this point, right? And so the general recommended approach is that you punt. So you send a pre-adverse action letter and you tell the person, we're not going to take any action unless and until this is rectified, meaning it's pending, so we're just going to wait and see. The one thing I would say, though, too, is first and foremost, if it's something that you don't care about, if the person is convicted, then hire the person, right? If it's a DUI conviction and the person's not driving for you, and it's a minor crime that was, 5 years ago, for example, you might just want to hire the individual. If it's currently pending and it's something that's related to theft, fraud, or violence, then you can do that punt, that pending pre-adverse process. But you wouldn't want to then take adverse action at that point.
Gotcha. Next question is, what if I'm not running credit reports? Does the FCRA still apply?
The answer is absolutely. So even though it's called the Federal Fair Credit Reporting Act, it's a little bit of a legal misnomer. The FCRA applies anytime that you are going to be getting information from a third party that bears at any point in time on the person's character, general reputation, personal characteristics, or mode of living, or credit. So a criminal background check, and that's all you're running, or a motor vehicle a motor vehicle record check, and that's all you're running, still going to apply.
Okay, great. And then I think you answered this one, you touched on this one. What if I'm doing my own reference checks? Do I still need to follow the FCRA?
The answer is no. And the reason being is you only have to follow the FCRA if there's a third-party consumer reporting agency involved. So if it's just you as an employer running your own checks, meaning if you're going, for example, and picking up the phone and calling a reference, that's going to be, certainly is not going to be under the Fair Credit Reporting Act. But be careful if you utilize any third party, for example, a database. I know we had a question that came in about whether or not you could utilize your database search, or you could do the checks yourself as an employer. I would be really careful because those companies could be and could meet the definition of a consumer reporting agency. So anytime you use a third party, whether it's online or whether you pick up the phone or you do an order, be careful about that because the Federal Fair Credit Reporting Act still may apply.
Okay. Can I combine the disclosure with my employment application?
And I touched a little bit on this in the presentation, and the answer is really no. You can combine your disclosure with the application process, depending on when you do that process and if you're in a state or local jurisdiction that allows the timing of that. but you don't want to have that be part of the actual application. What we generally find works very well for employers is that you do the initial application phase, you then give a conditional offer of employment, and then you do what's called a second pass. So it can be an onboarding pass or second employment application process pass, or you utilize the background screening companies, that third party's candidate entry system.
Okay. Are electronic signatures allowed for written disclosure?
They are, and really, so when you're talking about disclosures and authorizations, right, you have to have a written authorization. The disclosure you actually don't have to have signed at all, and whether you want to do that or not is really a question of what your disclosure looks like, what systems you're using, for example. But the FTC has opined that an electronic signature is absolutely just as effective as a wet signature for a written authorization, as long as you make sure that you comply with two things: the e-sign Act that went into effect many decades ago. It has very specific requirements, and then also UETA, which is the Uniform Electronic Transactions Act, and that's a collection of laws that about 46 states have now signed on to. So you want to make sure that you're complying with both of those to make sure that you have a valid electronic signature process.
Okay. If I run a credit check, can the credit check authorization form be included in the other documents, or should it be out on its own?
Yeah, so with credit, so what you really want to make sure is there's certain states that have requirements for different standalone documents, for example. So like, for example, California and Vermont and Oregon and Washington all have credit check laws. Illinois has a credit check law. Many of those don't have the requirement to have a specific standalone document. So most of those, you can say that you're going to be running a credit check in the disclosure form if you are running credit. Remember, in New York City, though, if you are not able to run credit, make sure you don't mention credit. But certain states are a little bit more unclear. Like Vermont, for example, is a little bit unclear. And so most of the time, if you're going to run credit checks in Vermont, we recommend that you have a standalone disclosure for that.
Do I need a third party to run my backgrounds, or can I just use one of the online database check tools to save some money?
Yeah. So we get this question a lot in terms of, can I run down to the courthouse, for example, or can I go and do an online search? So, obviously understand that background screening companies are experts in their field, right? They may have access to different tools and different sources of information. They also have certain regulations that they have to comply with, right? So understand that they have to take what's called reasonable procedures to ensure maximum possible accuracy. So you're going to be getting, hopefully, the most accurate and complete information if you use a background screening provider. And they also have, again, access to a broader brush of information, whereas if you go down to your local courthouse, you're really only going to get access to that court, for example. If you go online, just be careful. If you go to an online court repository, you may or may not know how to search their information, but you're only going to be getting one court. If you go, for example, to a database company, again, you really do need to be careful, because if there's a company that's actually aggregating information or assembling that information, they very well may be a consumer reporting agency, whether they believe they are or not. You also need to be very careful about the terms of use or terms of conditions if you're utilizing that, because many of those companies have very strict prohibitions on using that information for an employment purpose. And then you'd be violating not only their terms of use and terms and conditions, but also the law.
Yeah, certainly a situation you don't want to find yourself in. Do I have to follow the adverse action process if circumstance change after interviews and I end up canceling the job posting rather than hiring someone?
Oh, sure. So in that situation, if, for example, if you have, let's say you've given an interview and you're allowed to run a background check, or you've given a conditional offer of employment and then you've run the background check, and then before the background check comes back, you've decided, for whatever circumstances, to eliminate that job, right? The answer is no, you don't have to follow the pre-adverse and adverse action if the background check hasn't come back and you haven't used it in whole or in part in making a decision. Now, let's say it's halfway back. and there's something that shows that there's a criminal history on there that you may or may not be taking action on, but it influenced your decision, for example. Again, if it's in whole or in part, that would be a situation where you would want to follow the adverse action process.
Okay. And then should I specifically lay out in the pre-adverse letter what in the report was potentially disqualifying a candidate?
Yeah, that's going to be dependent on the local or state law of where the candidate is living or working. So there are certain jurisdictions that absolutely require you to list not only the actual reason in the background check report, but also, for example, New York City and LA, the individualized assessment factors that you weighed in and why that's job related. So you want to be careful about that. We get the question a lot of whether or not, for example, you want to, even in a state or jurisdiction where you don't have to, should you always tell the person the reason? And I think the answer is it really does depend, because there may be not one thing that goes into making your decision, right? It could be a compilation of things. It could be the fact that the person had a violent felony crime, 10 years ago, but they've also had 5 other repeat offenses. So that's not just one, right? But it's the multitude of the potential repeat behavior that could be causing the reason why you're taking action.
Pam, another one here. Do you expect ban the box laws to continue to expand or even expand more rapidly into other states and or even federally?
Yeah, we've seen a really steady legislation throughout the country, again, since really 2012, when the EEOC criminal history guidance went into effect. It certainly has slowed down a little bit, but we do think it's going to continue. Do I think there will be a federal law? I think a lot of that depends on the administration and new laws that might be passed. I don't believe that there's going to be a federal law passed anytime very soon.
2 more. I think we just have time for 1, maybe 2 more, Pam. We hire all over the country. Should we just adopt the strictest requirements everywhere?
Well, I think if you're thinking about, obviously, the federal law, that's going to apply anywhere you are, right? So the Federal Fair Credit Reporting Act is going to apply no matter where you are. If you're looking at a state law or a local nuance, I think for nationwide employers, many employers have chosen to take I'll call it the most conservative route, so that they have a consistent hiring practice across the board. And so that, for example, someone in New York City versus someone in Illinois versus someone in Texas aren't treated differently, for example. But, the key is that you want to make sure you have a written policy and a process that explains what you're doing. And frankly, you also want to make sure that you have the people that are doing the hiring process, the recruiting process, the background screening process are really knowledgeable about the laws and understand that the right documents, the right forms, the right processes are being given to the right candidates in those different jurisdictions.
Perfect. And then the last question, Pam, is are there any suggestions on how we can monitor the changing state laws?
Yeah, obviously attending webinars, things like this is going to be really helpful. I think keeping abreast of newsletters with different law firms, with background screening companies. I'm a big fan of alerts, right, with search engines alerts. I do think partnering with someone who is knowledgeable, making sure in the industry that is keeping aware of this is really, really important, because these very hyper technical issues that seem very, very innocuous can really cost you millions and millions of dollars, and for what potentially seems like little to no harm to a person. And these lawsuits aren't stopping. So I would highly recommend partnering with people in the industry who are knowledgeable.
And Pam, they could certainly contact you guys at Seyfarth Shaw, right?
Absolutely.
Perfect. Perfect. Well, hey, thank you so much, Pam, for again, spending a couple minutes with us today. And we'll see you again on Wednesday for when we dive into litigation strategies surrounding background checks.
Great. Sounds good. I look forward to it. Thanks, everyone.
Awesome. Thank you, everyone, for attending, and have a great day.